Welcome to this comparative reference video outlining the transition from the Indian Penal Code 1860 to the Bharatiya Nyaya Sanhita 2023. We will map the 50 most commonly invoked offenses from the old section to the new, effective from July 1, 2024. Starting with offenses 1 to 4, culpable homicide and murder definitions and their punishments are mostly retained, with the Bharatiya Nyaya Sanhita, or BNS, introducing a new section 103.2 for mob lynching. Offenses 5 to 8 cover causing death by negligence, dowry death, abetment of suicide, and attempt to murder. Noteworthy is the increase in maximum punishment for death by negligence from 2 to 5 years, with a softer 2-year cap for registered medical practitioners. Moving to offenses 9 to 12. Attempt to commit culpable homicide and causing miscarriage provisions are retained. The BNS separates the definition and punishment for voluntarily causing hurt and grievous hurt into new sections. Offenses 13 to 16 include grievous hurt by dangerous weapons and acid attack, which remain largely retained. Wrongful restraint and confinement definitions and punishments are similarly allocated to new sections within the BNS. For offenses 17 to 20, covering assault to outrage modesty, sexual harassment, assault to disrobe, and voyeurism, the sections are retained and mapped to new BNS sections, BNS 74 to BNS 77 respectively. Offenses 21 to 24 focus on stalking, kidnapping, kidnapping for ransom, and trafficking of persons. Definitions and punishments are retained and modernized, with trafficking exploitation forms preserved. Offenses 25 to 28 deal with rape and related offenses. The definition of rape is retained. Punishment for rape retains a minimum of 10 years. Aggravated forms and gang rape are consolidated or carried over with enhanced penalties. Offenses 29 to 32 include cruelty by husband or relatives and insulting the modesty of a woman, which are retained. For theft, the BNS adds community service for petty first-time theft of low value. Theft in dwelling houses is broadened to cover vehicles and places of worship. In offenses 33 to 36, definitions and punishments for extortion, robbery, dacoity, and criminal breach of trust are retained and mapped to the BNS. Specific sections detailing the definitions and punishments are provided. Offenses 37 to 40 cover cheating, counterfeiting, and forgery. The notorious IPC 420 for cheating is now BNS 3184, with punishment up to 7 years. Counterfeiting currency notes and banknotes are retained. Offenses 41 to 44 address forgery for cheating, mischief, criminal trespass, and house trespass. Mischief now features graded punishments based on the value of damage. Definitions for trespass offenses are retained and defined in BNS sections 329.1 and 329.2. Offenses 45 to 48 include defamation, criminal intimidation, and criminal conspiracy, which are largely retained with minor changes like the addition of community service for defamation. Notably, sedition is abolished and replaced by a new offense concerning acts endangering sovereignty, unity, and integrity of India. Finally, offenses 49 and 50 cover promoting enmity between groups and rioting. Promoting enmity is retained and expressly covers electronic communication. Rioting provisions are retained and mapped to BNS 191. This video offers a comparative reference of 50 key procedural provisions, mapping the old sections of the Code of Criminal Procedure 1973 CRPC to the new Bharatiya Nagarik Suraksha Sanhita 2023 BNSS, which is enforced from July 1, 2024. Provisions 1 to 4 detail changes in information for cognizable cases. Notably, zero FIR and electronic FIR are now codified. For offenses with 3 to 7 years imprisonment, a preliminary inquiry is permitted. Procedure for investigation mandates a forensic team visit for offenses punishable with 7+ years and videography of the scene. Provisions 5 to 8 include the examination of witnesses by police, where audio-video recording of statements is expressly permitted. Recording of confession or statements by a magistrate now allows electronic and audio-video recording. Provisions 9 to 12 address investigation and arrest procedures. 15-day police custody can now be sought in parts within the first 40 or 60 days of detention. The police report, or charge sheet investigation must conclude in 90 days. For arrest without warrant, prior approval of an officer is needed for certain offenses and persons. Provisions 13 to 16, concerning the rights of the arrested person, remain largely retained. This includes informing the arrested person of the grounds for arrest and not detaining them beyond 24 hours. Maintenance of wives, children, and parents provisions are substantively unchanged. Provisions 17 to 20 show minimal changes. The dispersal of unlawful assembly, conditional order for public nuisance, urgent orders in nuisance or apprehended danger, and search warrants are all retained with slight section number changes. Provisions 21 to 24 highlight the increasing role of electronic and digital means. Summons to produce documents now expressly covers electronic communication devices and digital records. The framing of charge must now occur within 60 days from the first hearing. Provisions 25 to 28 detail updates on charges and trial procedure. Plea bargaining is retained with time-bound application windows. Examination of the accused may now be conducted through electronic or audio-video means. Judgment must be delivered within 30 to 45 days of the conclusion of arguments and uploaded online. Provisions 29 to 32 pertain to bail. For bail in non-bailable offenses, the core discretion of the magistrate is retained. For anticipatory bail, the deletion of statutory factors leaves wider discretion to the court. The right to statutory bail is preserved, but staggered custody can affect the time calculation. Provisions 33 to 36 deal with bonds, detention, and absconders. A significant change is the maximum period of detention for undertrials. First-time offenders are to be released on bond after serving 1/3 of the maximum sentence, and others after half. Proclamation for a person absconding and attachment of their property remain retained. Provisions 37 to 40 introduce new measures. Trial in absence of a proclaimed offender is enabled. Every state must prepare and notify a witness protection scheme. Summary trial is made mandatory for petty offenses up to 3 years. Evidence may be recorded by audio-video electronic means. Provisions 41 to 44 cover witnesses, offenses, and appeals. Power to summon a material witness is retained. Compounding of offenses is updated to refer to BNSS offenses. Appeal against conviction and suspension of sentence pending appeal with bail provisions are also retained. Provisions 45 to 48 address the powers of the High Court and mercy petitions. Reference to High Court and revision powers are retained, with section number mapping changes. The familiar quashing jurisdiction is now BNSS Section 528. A new time-bound procedure for mercy petitions in death sentence cases is introduced. The final provisions, 49 and 50, introduce court-supervised attachment or forfeiture of proceeds of crime during trial and expressly enable electronic service of summons and conduct of proceedings by electronic means. This concludes the comparative reference of the 50 key provisions. This video offers a comparative reference of 50 key evidentiary provisions, mapping sections from the Indian Evidence Act 1872 to the new Bharatiya Saksha Adhiniyam 2023. These new laws are set to be enforced from July 1, 2024. Provisions 1 to 4 detail initial changes. Definitions of document and evidence are expanded to include electronic and digital records in BSA 2. Foundational rules for relevancy and the res gestae doctrine are retained. Provisions 5 to 8 mostly retain the prior legal positions. However, the definition of admission in BSA 15 now explicitly includes admissions made in electronic form. Provisions 9 to 12 address confessions. A key change in BSA 22 is the addition of coercion as a fresh vitiating factor for confessions. The bar on police confessions and the, quote, discovery exception are retained. Provisions 13 to 16 cover various aspects. Confession affecting a co-accused is extended under BSA 24 to cover an absconding co-accused. Entries in books of account now expressly include records maintained in electronic form. Provisions 17 to 20 focus on expert opinion and character. Expert opinion in BSA 39 is broadened to include any other field of specialized knowledge. Provisions related to character in civil and criminal cases are retained. Provisions 21 to 24 deal with facts needing proof and oral evidence. All rules regarding facts judicially noticeable, facts admitted, and the principles of oral evidence are retained without substantial change. Provisions 25 to 28 cover document proof. Primary evidence definition in BSA 57 now expressly recognizes electronic and digital records. Categories of secondary evidence are expanded to include oral accounts and copies. Provisions 29 to 32 address admissibility of electronic records and presumptions. Admissibility of electronic records requires a dual certificate, signed by the person in charge and a forensics expert. Presumptions concerning documents are extended to electronic records. Provisions 33 to 36 deal with the exclusion of oral evidence and the burden of proof. The exclusion of oral evidence by documentary evidence is retained. General rules on the burden of proof are also retained. Provisions 37 to 40 retain most presumptions. This includes the burden of proving a fact, especially within knowledge, presumption of death after 7 years, and presumptions regarding relationships. The conclusive proof rule for legitimacy of birth during marriage is also retained. Provisions 41 to 44 cover court presumptions, estoppel, and privilege. The court's power to presume the existence of facts is retained, along with the principle of estoppel. Spousal privilege and source privilege for information on offenses are also retained. Provisions 45 to 48 concern witness matters. Provisions relating to the competency and credibility of an accomplice, and that no particular number of witnesses is required, are retained. Rules on leading questions and cross-examination of hostile witnesses are also maintained. The final provisions, 49 and 50, cover refreshing memory and the effect of improper admission or rejection of evidence. Both these provisions are retained in the new Bharatiya Saksha Adhiniyam. This video will focus on the new provisions, specifically the newly codified crimes across the Bharatiya Nyaya Sanhita, BNS, Bharatiya Nagarik Suraksha Sanhita, BNSS, and Bharatiya Saksha Adhiniyam, BSA. We begin with the BNS, which introduces several new crimes. This includes organized crime and petty organized crime, which were previously covered by state laws. It also introduces a terrorist act and the concept of mob lynching or murder by a group, carrying penalties of death or life imprisonment. Continuing with BNS, we see a new offense for grievous hurt by a group on identity grounds. There's also the new limb for hit-and-run cases, and a standalone offense for sexual intercourse by deceitful means. Additionally, snatching is now a distinct offense separate from theft and robbery. BNS also replaces the repealed sedition law with a provision on acts endangering India's sovereignty, unity, and integrity. Community service is introduced as a new punishment for petty offenses. BNSS adds machinery for trials and absentia, and mandates a duty on every state to notify a witness protection scheme. Under BNSS, mandatory forensic investigation is required for offenses punishable with 7 or more years. It also provides statutory recognition for zero FIR, EFIR, and electronic registration. Furthermore, new fixed timelines are introduced for filing and deciding mercy petitions in death cases. BSA recognizes electronic records as primary evidence. Finally, BSA introduces a dual certificate regime for electronic evidence. Coercion is added as a vitiating factor for confessions alongside inducement, threat, and promise. The joint trial doctrine is extended to absconding co-accused, and there's a broadening of admissible expert evidence.